The Honorable Ryan Pinder, KC, Attorney General and Minister of Legal Affairs. The Honorable Justice K. Neville Adderley, retired, Chairman of the Securities Commission of the Bahamas. Ms. Christina Rolle, Executive Director of the Securities Commission. Members of the Commission, other distinguished guests, ladies and gentlemen, good morning. My name is Monique Sands, and it's my pleasure to serve as your moderator for today's briefing. We are pleased that you have been able to join us for this briefing, which will provide an overview of international initiatives, particularly updates on the OECD's Common Reporting Standard, the CRS, and the Crypto Asset Reporting Framework, CARF, as well as an overview of the National Risk Assessment and the Securities Commission's 2025 preparedness initiatives. As usual, we'd like to encourage your active participation in this exercise, and we welcome any further questions or comments that you may have after the meeting. And we're delighted to have our chairman of the Securities Commission, the Honorable Justice K. Neville Adderley, here with us this morning. So without further ado, we are going to invite him to bring some remarks. Chairman Adderley.
Thank you very much, Monique. Good morning. You know, looking out over the audience, it just occurred to me that without the females, we would not have any financial services industry. The protocol has not been established, so I will establish it to Mr. Ryan, the Honorable Ryan Pinder, Attorney General, Mr. Jerome Gomez, one of our board members, Ms. Christina Rolle, Executive Director of the Securities Commission, presenters, ladies and gentlemen. As the Securities Commission of the Bahamas celebrates the 30th anniversary, I am pleased to bring remarks for this industry briefing on international priorities and initiatives for 2025. The objective of today's industry briefing is to address, communicate, and sensitize the industry to the urgent international priorities and initiatives for the next 12 months. A top priority is the peer review of the Organization for Economic Cooperation and Development, OECD, Global Forum regarding the automatic exchange of financial account information and Common Reporting Standards, CRS, beginning in July of this year. Another priority is the Caribbean Financial Action Task Force, CFATF, assessment. The Bahamas is scheduled in the evaluated beginning March the 2026. This will determine the effectiveness of our anti-money laundering, counter-financing of terrorism, countering proliferation financing legislation, and the implementation in practice. Vitally, this briefing will contextualize the importance of our preparation for these reviews and provide an outline of the steps we must take to get the Bahamas in the best possible position for our eventual success. Let us be clear. The Bahamas has consistently adopted and evolved to meet those evolving standards set by the OECD, the EU, and the FATF. We are one of the few jurisdictions in the world that is compliant or largely compliant with the 40 of the FATF recommendations. This is no small feat, and we as a jurisdiction, inclusive of all stakeholders, should be commended for this accomplishment. Rules for the AML, CF, CFP are in place. You will hear more about our ongoing CFATF readiness, including focus areas, expectation of licensees and registrants, and data collection. You will also be appraised of the sustained approach that will be taken to conduct enhanced examinations and reporting to access compliance with the CRS and provisions of the AEOI Act and regulations and guidance notes of the AEOI, which were issued in August of 2018 by the competent authority and recently updated on the 21st of June 2014, 21st of June 2024, as well as other information gathering that the regulator will have to conduct. Practitioners should already have procedures to show that CRS and CFATF compliance. Although we have an established legal framework for CRS, we do not expect to be in a position to pass with flying colors. We must show we are on track, and a strong effort has been made to implement a pragmatic framework that is compliant and mitigates risk to pass this assessment without being blacklisted. To bolster our preparedness, there will be technical training and other initiatives to assist the industry, which will be outlined this morning. Let us not for a moment presume that this is a routine assessment to be underestimated. If we are to survive as a financial services jurisdiction for international business, we must tackle this challenge with an appropriate level of seriousness. Successful navigation through these reviews will require all hands on deck. Policymakers and regulators must do their part, and the private sector must cooperate and do its part. The cohesive effort is required to ensure the jurisdiction avoids the essential threat of blacklisting. I think that bears repeating. Policymakers and regulators must do their part, and the private sector must cooperate and do its part. This cohesive effort is required to ensure the jurisdiction avoids the existential threat of blacklisting. There's a lot to do. This will not be simple. It will impact your day-to-day operations. This means when we request information or completion of surveys, it is not our intention to be burdensome. We require accurate information to satisfy the evaluators that we are compliant. The famous American blind, deaf author and activist Helen Keller famously said, "Alone we can do so little. Together we can do so much." Collaboration between the government, regulators, and the financial services industry at large will ensure that on the global stage, we continue to maintain compliance with international standards and best practices. We hope you find this session informative and look forward to your cooperation. Thank you very much.
Thank you, Chairman Adderley. Our first session this morning is a moderated question and answer session with the Attorney General, and Minister of Legal Affairs, the Honorable Ryan Pinder, KC. This session is going to be focused specifically on international initiatives, and it's going to be moderated by Mr. Samuel Campbell Jr., who serves as an assistant manager in the Office of the Executive Director. Please welcome both gentlemen.
Good morning.
Good morning, all, and thank you for taking the time to join us in this, what we call it, coffee side conversation.
Yeah, we don't have a fire, so it's not a fireside chat.
Kind of moving away from that, that phrase. Thank you, AG, for joining us, taking the time to join us this morning, which I think will be a very provocative and transparent and informative conversation. So let's just jump right into it with something that recently was in the news, and I know your office and the government generally had a response to this, but the recent U.S. International Narcotics Control Strategy report talked about the Bahamas had some deficiencies in combating money laundering and financial crime, and citing a lack of convictions and asset seizures. What is the impact of this kind of report on the international perceptions of the Bahamas, and what can we do to kind of combat this narrative, or change this narrative?
Yeah, well, before we go there, I think it's important to say that I held up a mirror and showed it to the U.S. and said, why don't you look into it? Because, frankly, that's one of the most hypocritical reports that I have seen. If you just look at what the U.S. does with respect to prevention of money laundering, it's black and white to what we actually do. If you look, they have a FATCA regime that is contrary to the global standard on automatic exchange of information. They have made a decision now under this current administration that they're not going to collect beneficial ownership of companies. That is the underlying predicate of the fight against money laundering. In fact, yesterday, FinCEN released an interim final rule that said that they will not collect beneficial ownership of any company incorporated in the United States. Any company incorporated in the United States, whether it has foreign shareholders, U.S. shareholders, they just won't do it. And they will only collect beneficial ownership information on foreign companies who are registered to do business in the United States. And in those circumstances, only for foreign shareholders, not U.S. shareholders. And so you tell me how, taking that position as a regulator in the United States, they can hold any type of credibility when they talk about anti-money laundering activities of other jurisdictions. I want to say that as a predicate. It's unfortunate that they keep publishing the same report year after year, effectively with the same language year after year, without taking into consideration any of the progress in which the country has achieved with respect to anti-money laundering. Of course, it's not helpful. Of course, it's damning. And what's really not helpful is when some of our local journalists put provocative headlines in the press that describes a report that really, in my mind, holds no credibility. That's a shame as well, and we really, our journalists really have to look in the mirror themselves and ask themselves, what are they trying to accomplish with that? What can we do to address this situation? Certainly, the executive director and myself have been speaking in recent months about a high-level delegation to Washington to speak with the Treasury Secretary, to speak with the State Department, to speak with the SEC, to speak with some of their digital asset policymakers, to be able to speak more about the Bahamas. We think that in some of those rooms we would have friends that would at least listen and try through high-level diplomacy to change the approach of what the United States feels they need to do with respect to these types of periodic reports. But needless to say, when you look at jurisdictions, it's clear the differentiation between what we do and what they do. We are 40 for 40 in FATF recommendations, one of very few countries in the world. At the time we achieved it, one of only 6, only the second in our hemisphere. That is an achievement that the United States has yet to trumpet on our behalf, and it's something that I think that they need to do. So we'll engage in very high-level diplomatic efforts. We'll keep telling our story and speaking our narrative. But it's really unfortunate when these countries don't recognize what we do, when they look in their backyard and they're designing their regulatory framework to create clear regulatory arbitrage to attract illicit funds to their jurisdiction. And that's what they're doing. And for them to condemn a country like the Bahamas when that's actively what they're doing is really shameful.
Yep. I guess piggybacking off, you talked about us having 40 to 40 of the FATF recommendations. For those in the room who may not know what FATF, CFATF, these letters mean, could you explain what they mean and what is their role in the regulatory landscape, and how is it that they became kind of the global standard setter for AML and CFT?
So the Financial Action Task Force is the FATF, and that's a global multinational body that's in charge of assessing and putting out regulatory standards for the fight against money laundering and for, that's yours, eh? All right, I'll continue without him. The fight against money laundering and terrorist financing. And so, that again is a special members club like the OECD, primarily of top economies of the world that make rules for other people to follow. The Caribbean Financial Action Task Force is a regional body of the FATF that we're members of. And so they do a little better than the OECD, only a little bit. But they allow us a forum in the region to speak on these matters, although we don't really have representation at the FATF level. It just so happens that last year we approved the United States as being a full member in the Caribbean Financial Action Task Force. It's interesting because I didn't realize they were in the Caribbean. But some of our regional colleagues seem to think that having a full member of the FATF was helpful around the table at our meetings at the CFATF level. And so I will certainly raise the matters that I spoke about on your first question at our plenary that is coming up in May, where we will have our first plenary with the United States as full members, and we will see what their response is.
Okay, and what is the significance of being compliant with these recommendations? So there are 40 of them, right? And what's the significance of being compliant, and what's the significance of us having 40 out of 40?
So, these are the 40 global standards of compliance of every element of the AML regime that has been put in place globally. As I said, there are very few countries that have achieved compliant or largely compliant status with respect to those. Very few have, for instance, achieved compliance at the virtual asset service provider level, VSAPs. We have, even after, in fact, we achieved our compliance rating even after the FTX collapse, right. Which is very interesting. It demonstrates certainly our regulatory framework was respected. And so, I think, certainly reaching that achievement is when you speak about global standards on AML, is the pinnacle. That's the top. And we value ourselves for being there because you can't be a country that is non-compliant on money laundering standards, unlike some of our neighbors to the north. And a small financial center like the Bahamas must achieve standards that are above the bar that is being recognized globally in order to be able to demonstrate that we are a jurisdiction in which some of our clients from countries all over the world should do business. And so something that we work to achieve, and we work very hard at it. You would have noted, I think many people may have been in the room, when we had a consultation on our AML National Risk Assessment only a couple months ago. That's actually recommendation 1, fulfilling your obligation of having a self-assessment and a national risk assessment. And so we published that a couple of months ago. We did a lot of work on that. That is work that is done out of my office in cooperation and coordination with all of the regulators, and to a certain degree private industry, to be able to have a self-reflection on our compliance on anti-money laundering. We did that in preparation for the upcoming 5th round mutual evaluation of the Bahamas. That is scheduled for next year, October. However, it is almost a 12-month testing period in which they will look at, the FATF assessors will look at our actual implementation of the rules and implementation of the standards and whether we're complying on a day-by-day basis with what we have put in law and what we have put in policy to reach our 40 for 40. And so that's going to be a lot of work. You're going to see some changes. You're going to see some legislative amendments put forward, and you're going to see the regulators really taking a look at your implementation levels, not if you have your policies and procedures, but if you're actually doing it on a day in and day out basis to prevent the AML standard. Because one thing we can't now do is we can't move backwards from where we are. And once you're at the top, there's only one way to go if you don't stay at the top, and that's to the bottom. And we can't tolerate that, and we can't afford to slip in any of these areas.
And with that evaluation upcoming, do you see any you foresee any changes in the assessment methodology that we should be aware of?
Well, yeah, there'll certainly be some changes, because also the FATF issues updates to their recommendations. And so, for instance, we've seen a material update to recommendation 25, which deals with legal arrangements, and specifically this deals with trusts and fiduciary structures. And what the new recommendation 25 is looking to do is create a full KYC framework in the trust industry. And so that just doesn't mean your settlers, but your settlers, your beneficiaries, your protectors, those who have effective control over the trust. All of these now will have the KYC obligations as the corporate services companies in the room do for their corporate services clients. Now there's going to have to be a robust framework for trust. And so you will see some proposed amendments to the Financial Transactions Reporting Act dealing with Recommendation 25, new recommendations, as well as some on companies in Recommendation 24. You'll also see, for those also in the fiduciary space, some changes with respect to Bahamas executive entities, Bs. Right now, there's no kind of regulatory interface between a B and any of the regulators. And it is the view of the FATF that a B holds a certain fiduciary responsibility. And therefore, having an entity that would have fiduciary roles and not have a connection with a regulator is troublesome for them. And so what you're also going to see, you're going to see some amendments forthcoming that address the B and treat it more like a private trust company. So not a full licensure regime, but kind of a registration regime and monitoring regime for the B that's going to be akin to a PTC. And so you're going to see some of those changes legislatively. And we want to get those changes done in the next month or two, certainly before the summer recess, and hopefully before the budget debate, which generally starts the 3rd week in May, in order to be able to give time to the industry to start implementing those changes as well. And it's going to be very important for the trust industry and those who are fiduciaries to take a good look at that, with respect to to implementation and also give you time to get the relevant information from your clients. Because like I said, they're going to look back a year at least to make sure that we're compliant on that. So those are some of the changes. Another revision for those who are on the corporate services side, there are some changes we're working through with respect to nominee shareholders and directors. And what you have to do, you effectively, what they're requesting is if you act as a nominee, that you have to, one, indicate on a register that you're acting as a nominee, and also indicate who you're acting on behalf of. And the question we're working through on that is one, which register, and there's a determination that they should be regulated in some form or fashion. So what we're working through, really two prongs of that. One, we know that the central bank has a regulatory regime for nominee trust companies. And we know by the letter of the law, the Securities Commission, under its Financial Corporate Service Provider Act, includes acting as a nominee as a corporate service, and therefore you should be hold a FCSP license if you're acting as a nominee. However, we also know that there are service providers, and particularly small service providers throughout the jurisdiction, who act as nominees and are not regulated under the central bank regime or the Securities Commission regime. And those include some accounting firms, those include some law firms who act as nominees, and probably some other general service providers who aren't regulated. And so I think what we're going to have to do on the regulatory framework on nominees is prescribe in law that you cannot act as a nominee unless you hold an FCSP license or you have a nominee trust company license through the central bank, and make it clear, especially the small service providers, that they're going to have to hold some sort of license to act as a nominee. The second question has to do with nominee directors. And there is a distinction between acting as a corporate director and acting as a nominee director. As a nominee director, you're effectively the agent of somebody. As a corporate director, you take the fiduciary responsibility on yourself as a corporate director. I think for the most part, and I think this is something that we're going to have to poll industry on to get an understanding, but I think for the most part, our industry, when they act as directors, they act in a corporate director capacity and not a nominee director capacity, if you get the distinction between that. And therefore, what we may end up doing to facilitate the registry component, you would note I said you have to have it on a registry as well, is we may, I'm floating this out here for the first time, but we're thinking about banning nominee directorships entirely. Allowing corporate directorships, allowing you to act as a fiduciary, but not, quote unquote, as an agent or nominee on the directorship side. If we do that, then we think that we can put the registration for nominee shareholders through the BOSS system, which would be much better than the alternative, which would be putting it at the Registrar General in a public framework. And so that's kind of the things we're working through on the nominee shareholder and director side, and those are recommendation 24 revisions that we have to work through. And so I kind of float that out there. I know this is probably the first time you're hearing that because, Christine, I think we had that call maybe 10 days ago, if that, maybe last week, to talk that through. So this is a new development, but we're working assiduously to get a framework in place to float to industry. We'll put these out to industry to review, certainly, before we proceed with them. But those are some of the more significant legislative and practical changes or revisions that you will see coming out in the next month or so that deal with some of the changes when it comes to FATF requirements and AML requirements that we have to implement.
Okay, yes, that's quite a lot to absorb and a lot of work to do going forward. Let's pivot a little bit to some of your international advocacy passion projects. You've been making the news globally for your advocacy at talking for fairness at the international tax policy level, particularly so nations like ours in the Global South have a fair seat at the table, because obviously when some of these rules are let out, we are disproportionately affected. Can you talk about the current system and what do you think is the proper forum to kind of deal with these international tax policy measures?
Yeah, I'm happy to do that. I mean, I think those in the room know my position on this. I've been rather vocal on this. I think members clubs like the OECD and to a certain extent the FATF are designed to create inequitable standards and inequitable treatments to countries who are not members, including small financial centers like the Bahamas. When they talk about at the OECD level being an inclusive framework, that's really makes me chuckle, because you tell them you want to join a system with the rules already established, not having input in the rules, and you have to pay to be a part of it. So really, it's not inclusive at all. And we see different standards being put in place from the OECD and the FATF when it comes to their membership and those who are not members and not allowed to be members. We look at FATCA and the CRS as a clear example of that, where the U.S. has been allowed to manipulate the system to create a regulatory arbitrage, even though they're members of the OECD and, frankly, the largest contributors to the OECD. Well, maybe not under this administration anymore. And so I think there's absolutely a framework of inequality globally when it comes to financial regulation, whether that be tax, whether that be AML, whatever that might encompass. And frankly, it's just not fair. When you look at the list of the largest countries where there's illicit funds in, you look at places like the United Kingdom, you look at places like the United States. And so clearly there's a double standard there. I believe, as does the Prime Minister and our administration, that global regulation in these areas should be based on a one country, one vote type of framework. We should all have input. We should all be able to help scope the rules. We should all be able to help contribute to a framework of dispute resolution. We see unilateral blacklisting, for example, that is being done by these multilateral institutions as well as blocs like the EU. And it's a unilateral dispute resolution mechanism that they choose to do that really has absolute devastating effects to countries like the Bahamas, whether that be just client retention or whether that frankly be as simple as having correspondent banking or being able to do international trade. And so, we believe, and I've been rather active at the United Nations. We have passed a resolution that asks the United Nations to create a global convention on tax cooperation. It is clearly a jurisdiction where you see the global north countries and members of the OECD at odds directly with the global south. Good thing we have more numbers in the global south than the global north, and we can keep the process moving forward. The unity amongst the global south countries is rather impressive, and we think that we're making significant progress. We have approved the terms of reference for the convention. That has been approved through the committee and the General Assembly for the United Nations. And we are now involved in setting the framework and negotiating the actual convention and the early protocols. And the goal is for this to create a more equitable treatment of global tax regulation than we witness at the OECD, for example. We're rather confident and optimistic that we can make some progress. We've chosen 2 early protocols as part of the global convention, and really the protocols are where the details of regulation lie. The first one has to do with taxation of cross-border services, especially in a digital environment. And as a service-based economy, we feel that's very important for the Bahamas to understand where the taxation and who should claim taxation over cross-border services. That's the first early protocol. We will participate as the member of that negotiating committee on that protocol, we being the Bahamas, we being me. And the second one, which was very important for me and I think us, is we have an early protocol on dispute resolution. I've always maintained that unilateral blacklisting by countries and by these multilateral organizations are their effective way of dispute resolution. And it's a unilateral version of dispute resolution where we really have no say, and if they really have a problem with what we're doing, there should be a mechanism in which they engage us, a mechanism in which there's bilateral workflows, and an understanding what the ultimate dispute resolution end goal would be. And that's how we view dispute resolution. We don't view it as unilateral punitive measures from one country against another just because one country is stronger than the other. Economically stronger. And so we were successful in having dispute resolution as an early protocol in the convention. Again, we're members of that negotiating committee on dispute resolution. And I think we're very confident we will have our voices heard. I'm certainly not a passive participant in this process.
Yeah, I mean, you've always been very passionate about this unfairness in terms of tax policy, so we're cheering for you and wish you continued success as you continue to advocate for us.
Thank you.
I guess another part of your international advocacy has been your arguments for climate financing and climate justice. You've been making arguments in The Hague and the ICJ around holding countries accountable for historical and environmental damage. Mm-hmm. What do you hope an ambitious ICJ advisory opinion can do to address some of the gaps in terms of international framework and make climate justice more accessible to countries like ours?
And actually, I'll speak to this. What I just spoke about in the tax convention and what we're doing on the climate justice framework do come about and are connected. Yeah. And so the United Nations asked the ICJ, International Court of Justice in The Hague, to issue an advisory opinion on climate justice matters. And specifically what they asked the International Court of Justice to opine on is if states themselves, countries, could be held liable in law for the failure to either create or enforce regulatory regimes that are designed to protect harmful activities to the climate and contribute to the climate crisis. And so, you look at some factual circumstances, you look at, there's historical documents out of the United States, for example, in which they turn a blind eye to the oil and gas industry over decades, knowing the damage is going to occur to the environment, turn a blind eye and let it go forward, and ultimately direct link to the climate crisis that we're experiencing. And so the question to the ICJ was, can states themselves, and certainly the United States is not the only example of this, there's others, but I just use them as an example, can states themselves, in other words, in my example, the United States of America, be held legally liable as a state for the failure to enforce the regulatory framework to protect the climate or to avoid the climate crisis that we see happening. We think that's a very important determination, because that now takes it out of a kind of private company litigation framework and brings it into a diplomatic, a state-to-state framework. We're hoping for a decision by the ICJ this summer. Certainly I was in The Hague at the end of last year presenting our oral arguments on that matter. And we hope that with a favorable determination by the ICJ, we will really see a change in global climate finance. We've seen the diplomatic efforts at the various COPs, conferences, conference of parties for the climate crisis. We've seen how we've tried to advance climate finance at the diplomatic level in that. The Loss and Damage Fund, which still isn't formed and funded, and that's 2 years ago. We had in the most recent COP a discussion about climate finance where we were looking at $3 trillion, and they settled on, I think, with $300 billion or something like that. It's a drop in the pan. And so in that environment, the resistance to climate finance at the diplomatic level is significant. Now, if we get a favorable determination, we think it opens the doors with climate finance. One thing we were successful in negotiating in the terms of reference of the United Nations Global Tax Convention was a recognition that global tax policy and the environment are connected. And it's in the terms of reference no fewer than 3 times that they speak about environmental matters and taxation together. Now, what we're hoping is that and that was intentional, that was something that the small island developing states really pushed for in the terms of reference. And what we would hope is that with a favorable determination at the ICJ, we now have legal authority to really push the envelope in something like a global tax convention, to put a framework of an environmental tax in there where the polluting countries may have a special tax regime, whether it be a carbon-based tax or some sort of environmental tax, that will now help fund these loss and damage funds and these other climate finance mechanisms that we've been working on diplomatically. And so, when you look at how these things are working on the global scale, you kind of have to have a vision and put it all together. We're hoping with the ICJ opinion, like I said, and with the terms of reference on the tax convention, that we can bring them two together and help with some innovative climate finance designs from a global tax policy to help us with what we struggle through on the climate crisis in countries like the Bahamas that really have no effect on what's happening globally with climate finance and climate crisis, but we feel the effects. We know 40% of our aggregated national debt is attributable over the years to rebuilding initiatives after hurricanes. And that's only getting larger and larger as the hurricanes get more and more severe. These are just tangible examples of how financially the climate crisis is affecting us and whether we can use other mechanisms to help address those issues.
Great. I guess to pivot a little bit back to the more local sector, you've mentioned proposed reforms to the companies and insolvency regime. Can you provide an update on where we are with that, and what is kind of the focus of this reform, and what are the benefits, proposed benefits?
So I think it's important to start out what is the impetus for us to take a hard look at our companies law and our insolvency law and take that mammoth of a task on. We see the evolution of our industry in a way where the future is not us being an offshore financial center. The future is us being a nearshore financial center. And you can see that with the evolution of global tax regulation, with BEPS, with economic substance matters, and you see that with us having to build companies that are actually present and doing business in the Bahamas and the interconnection of trade. We want to be a nearshore jurisdiction. We want to be the closest Delaware to the United States that's not in the United States. I think that's kind of where we see the industry moving, where we see our place in this global environment developing. And if you're going to do that, you're going to have a business model that looks to attract clients to the Bahamas physically, to do business from within the Bahamas to a certain extent, to have some kind of residency in the Bahamas, and be able to demonstrate that. And to do that, you need a corporate regime that's modern, flexible, has new types of entities. I mean, limited liability companies have been around for a generation, if not more, and we don't have them in our framework. Can we have a kind of corporate structure that is flexible and would be respected and treated as a pass-through for tax purposes, for example? And so we're looking hard at our companies regime. Do we need a Companies Act regime and an IBC regime any longer? Right? Why? Why would we need that? If we're becoming nearshore and we see economic substance being more and more being developed as a global standard, why do we need a Companies Act regime and an IBC regime? Why shouldn't we have more variety of partnership regimes in the Bahamas? And so we're taking a hard look at that. We benchmarked. We have a benchmark study, and when I say we, it's the Attorney General's Office and the Securities Commission of the Bahamas, and the Securities Commission of the Bahamas has been invaluable in this process, and I want to thank Christina for her support, because she's got a larger budget than I do. And so we're taking a hard look at that. We've done a full benchmark globally on what we see internationally, what we see as the development of corporate structures and how that works, with a mindset to do a full overhaul of it. And I think we're going to launch that, Christina, probably in the next week or so, with our external advisors to actually start drafting instructions and what would it look like. But in this world of trying to be nearshore and trying to be a preeminent structuring and business jurisdiction, you need a proper insolvency regime, because businesses go out of business. And we've seen that in the Bahamas. And certainly we're not criticizing the effectiveness of what we have. I think some of the recent insolvencies will demonstrate that our regime is effective, but it's not necessarily equivalent to what we see as globally accepted standards. And right now, from a structuring point of view, our insolvency regime is built into our company's legislation. Now, is that appropriate? Should we have a standalone insolvency regime that applies to any type of entity and applies to individuals themselves, and has maybe more creditor rights than we have in our current regime? And so, we think in order to attract global business here and global service providers here, we need an insolvency regime that reflects being a nearshore jurisdiction, and that's really state of the art and certainly recognized as such internationally amongst our peers. And so again, we've undertaken already a global benchmark, a rather comprehensive benchmark on insolvency regimes around the world. What are the best features of different regimes to be considered? And we're going to again launch that probably next week with our service provider in creating drafting instructions and trying to formulate a piece of legislation that would really set us apart from other traditional IFCs with respect to an insolvency framework. We believe both of those activities are past due for modernization, but we believe they're both necessary as we see where global industry is going and where the Bahamas may fit in that evolution. And so those are two mammoth tasks we're taking on in partnership with the Securities Commission. We hope to be able, if we can get started in the fall, have something to be able to consult on with the wider industry. And certainly this is something I look to try to pass through Parliament before the next general election.
And I guess with this in mind, is there anything else you think that we need to do as a jurisdiction to remain competitive? This is a big aspect of it, but what else do you foresee us?
Well, I've always really valued what we do here when it comes to our cooperation between industry, certainly led by Bahamas Financial Services Board and NIKEA, and the regulators and government policy, right? I mean, I think it's something we continue to excel at. A week doesn't go by that I don't speak to NIKEA on behalf of the industry, or Bruno on behalf of AIBT, or Christina, or the governor on regulatory matters, and it's not even within my portfolio, right? I'm just the Attorney General. And I view that highly. Now, I've always said that from when I was the Minister of Financial Services and before that. But the real benefit of having that is having the knowledge to react as a jurisdiction in the face of changes in other countries, and specifically changes in key markets for us. And being able to understand what's happening in those markets, and industry feeds us that information, and then kind of being innovative and say, okay, how do we reposition ourselves for those jurisdictions, because we've invested heavily in those jurisdictions to have a profile, and then working with the regulators to say, okay, these are our thoughts, I think this is what we have to do. I'll give you one example of that we're working on right now, and it has to do with some of the recent tax changes in Brazil. Now, those of you who are either fund administrators or even corporate service providers which have a reach in Brazil would say, look, these recent tax changes, the control foreign corporation regime that they've put in place, the elimination of deferral by using funds, onshore, offshore funds, and our ICON that we work so hard to leverage our presence, all of that now is ineffective because there's no more tax deferral for Brazilian clients who have an offshore fund. And so that's important to the Securities Commission because they get license fees from funds who are licensed, and if there are no funds, there are no license fees, and it affects them as well. And it affects their licensees. And so the question is, how do we react and what do we do? And so we've been having a dialogue with industry, and particularly those members of industry who are very active in that jurisdiction, and even reaching out to some of our strategic partners in that jurisdiction to talk through what's happening and to talk through how we can respond. We believe that one of the changes we did last year in anticipation of this, when we passed an amendment to the IBC Act to allow demergers as a functional law, in other words, instead of two companies coming together, we allowed a demerger or one company coming apart as a function of law and therefore not deemed to be a distribution and therefore no tax effect. That helped with some of the unwinding of some of the structures, especially in Brazil, that allows us to keep some of that structuring work. Another thing we've really seen some of the industry say is, look, we have these segregated account companies that are funds that are really all over. They're in Cayman, they're in the BVI, we have some in the Bahamas. And we really need to think about how we restructure these as a matter of law, function of law, rather than a deemed distribution. And it complicates it because funds are regulated, SACs are regulated, and how do we now take it to where we can kind of separate out that SAC and all the underlying cells, which are not incorporated entities, and be able to spin them off as independent companies with the respective assets to go to the respective shareholders, because imagine some large families use these for family structuring. They may have different classes in the SAC with different cells, and each family may have assets in a different cell tied to a different class of shares, and that's their family structure. How do we unwind that without them having a massive tax hit, for one? And secondly, how do we unwind that where we can keep the work? And in fact, we can not only keep the work, we may be able to grow the work, because Cayman or the BVI or some other jurisdiction where it's structured may not have this in law. And we may be able to re-domicile all of those funds to the Bahamas and then have this workout structure to be able to unwind it. And so we're actively working on potential amendments to the segregated account company regime to allow for this. And that's a long-winded kind of technical discussion on what do we have to do. We have to do what we've always been good at. We have to identify opportunities that exist in markets that we are active in, and maybe markets that we're not active in and we should be active in, and invest ourselves in those markets. And that's not only the government investment, right? That's the regulators' investment, but most importantly, that's the industry's investment. You know, I remember when I was Minister of Financial Services and we had launched the ICON, the Smart Fund 007, and things were hot, and we were getting Brazilian structures all over the place, and everybody had their fingers in something coming out of Brazil. And we did a trip, and we did a roadshow, a landfall to Brazil. We had 20 service providers, 25 service providers traveling with us. Now we do a trip, and if we have 4 service providers traveling with us, that's a lot, right? And so you can't expect to access jurisdictions. You can't expect to create relationships with service providers in other jurisdictions. And you can't expect to understand opportunities in these jurisdictions if you don't go to these jurisdictions. And that's something where I think we have fallen off of as an industry. I still say I'm from industry. But I think it's something we've fallen off of as industry in the last few years, is industry's investment in the industry itself. And I think that's paramount and that's important, because we are nimble, we can pass legislation very quickly, right? We can promote ourselves, and we're good with clients and we're good with other service providers, and we understand complex structures as service providers in this jurisdiction. But we have to commit ourselves to understanding the changes that are occurring, figuring out where we fit in that, and then communicating that and actually going and investing yourself in that. And if we don't do that as an industry and take advantage of what we actually have, then we're not going to pivot like we have historically. We're not going to find new markets. We're not going to find new clients. And ultimately, we're going to shrink, we're going to recede, and we're going to be a figment of what we used to be. And we shouldn't allow that to happen.
Yep. I guess another aspect in terms of what we're doing to remain competitive and more efficient is your offices overhauled the Registrar General's Department. It was announced last month that they've officially been split into 4 different registries. Can you update us on the progress of that reform and some of the issues your office may be seeing, particularly from the company side with cars, et cetera?
No, absolutely. And I want to thank the industry for their patience and cooperation on this. Any new launch, any new initiative is always bumpy at times. And I appreciate it, and I've always been rather patient in this process and listening and trying to rectify issues personally on these things. I think CARS is definitely working much better and much smoother. At least I don't get the calls I used to. So I gauge that as that it's working better. So, as y'all would know, and you know, I think most of you have my number in this room, so you can certainly, if I'm wrong, you can tell me I'm wrong. But based upon the statistics, we have seen a dramatic increase in service providers using the platform. We've seen a significant amount of transactions and activity on the platform that is being handled and handled successfully. And so the trajectory of use and the trajectory of kind of successful completions, the statistics demonstrate that it's doing well. as all of you would know, and it's going to be a fantastic system once we've rolled everything out. It's a digital platform where you can do your incorporations, you can do all of your updates of directors and officers, and get certified certificates of good standing in the whole 9 yards. The largest challenge to CARS has really been historical data. And when we launched, we kind of launched for new incorporations and new activities while we worked through some of the historical data issues. And the last thing I'm going to do is put in correct data up on the portal, because that has an effect on your reputation and your ability. Just to give you a context, we had 5 different databases of companies' information. 5. We tried to merge all of that data, and clearly some was inconsistent. And so we didn't put that, obviously, up on the system. And so what we're doing, we're doing manual verification of all of the data that came back with inconsistencies in it. And so part of the challenge in working through that expeditiously is a human resources issue, because you have to actually have data entry clerks doing this physically. We've now expanded that to I think we have about 9 data entry clerks now, specifically on CARS. We're trying to build that up to 20 to be singularly focused on putting the historical data, so when you go with an old company, you'll be able to get everything as well, and everything up to date. What we're also doing, and this is one thing I have to thank the financial secretary for, is he has authorized a massive scanning initiative of all the company files that were pre-digital era, which I think they started putting scanning in around between 94 and 96. They started it with new companies. So everything kind of pre-96 is still paper. And so we're doing a scanning initiative to try to get all of that scanned and in the portal. So at the end of the day, what we would want is, from a company side, everything that was ever a piece of paper is now in a digital format and tied to the respective companies, so you could have that database going all the way back. And that's underway now. Next month, we will launch what's called CARS Business. And CARS Business is an optional subscription program for service providers, which creates your personal portal. And this personal portal ties directly into CARS and can tie directly into your billing software that you use. But what it is, it effectively, it achieves a few things. It's a whole client management portal. So from a corporate services point of view, so all your client information in there, all your historical stuff will be in there. And what it does, it also tracks your user profile. So you can see your corporate services users in your firm, what files they're working on, how much time they're spending on different files, what's taking the most time, if they're being efficient. So it really helps from an internal company operations point of view. 2 important features which it will have that would be important for many of you is, one, it's going to have a bulk upload feature. So for instance, one of our piloters, we've been piloting it, one of our piloters uploaded their annual registrations for 98 IBCs on the push of a button in a spreadsheet. And they did all their annual registrations for 98 IBCs within 10 minutes. And they couldn't be happier, rather than doing one by one by one by one. The second function that CARS Business is going to have is, especially for those international operations. Right now, you would know, and I've heard a lot of criticism on this, but there's a reason for it, that you can only incorporate or do whatever function you're going to do from within the jurisdiction and from an IP address in the jurisdiction. Well, that is to preserve, one, regulatory integrity, because only Bahamian regulated companies should be doing corporate services businesses. and to ensure that we know who's doing what. But what CARS Business will allow you to do is that it will now allow you to have a foreign office interface with CARS or the preparation of CARS. So say your foreign office has all the client has the client instructions, and instead of emailing back and forth, what they can do is they can populate the submission. So they can change the director, or they can change a shareholder, or, you know, they can change the capital in the company, but they can't process it. So they would effectively prepare everything, and then you would come online and you would look at it, vet it, verify it, and file it. Again, from within the Bahamas, but now you are able to have a foreign office interface with your corporate services that you're doing. For a lot of the multinationals, we heard that in our launch of CARS that this posed an issue for them. I question whether their foreign offices were doing regulated activity, Christina, if it posed that much of an issue for them. But the point they were making alternatively was, you know, we have relationship managers in other jurisdictions who interface with the client and who take instructions, and the efficiency would be a lot more if we can have the input of our foreign office in the corporate services that are going on in the country. And so our CARS Business will allow for that functionality as well. And so you'll see that roll out in April. We'll do a big demo. We'll do something like this to show you what it's like, and everything gets deducted out of your escrow account, so there's no separate writing of checks or separate service provider or anything like that. Everything just comes out of that. And so we think, you know, we're progressing well with CARS. We think it's evolving. We just finished advertisements for a registrar of companies, because, as you said, we're splitting companies from what we call records, which is the civil side. We pulled IP, intellectual property, out of companies and created a separate IP registrar, because we think intellectual property is something we really have to modernize, and we have to be really at the front of the line. I think it's a revenue source, it's a business source, and it's what our clients want. And then we're going to launch, as you know, registered land. We've been talking about that. You'll see that go to Parliament next month. We're proceeding with that. We're going to have a standalone land registry. So for you who are involved in land, we're going to launch in April our digital platform for the civil side registry, and particularly deeds and documents. So you'll be able to access deeds and documents, register deeds and documents electronically, not having to go into the registrar, be able to fill out the information, upload the document, it gets confirmed, and you get to do that. And then we'll be launching the land registry by the end of this fiscal year. And so we're doing a lot with the registrar. It's a mammoth task, but sometimes you got to take on these big tasks because you believe it's for the betterment of the country and betterment for industry. I want to again thank you for your patience while we do that. I'm always happy to hear your input and your suggestions. But I certainly think that the efficiencies that are ultimately going to come from this are going to far outweigh the bumps in the road that we may have experienced on launch.
Okay, great. So that's a lot of good information and updates from the AG. Any questions from the audience? We have about 5 minutes for questions.
No? Reese? Nothing? Yes, please.
Nearshore jurisdiction, I firmly believe that we'll need the support of the United States in that regard, because we are very much their near neighbor. You mentioned us becoming sort of the Bahamas equivalent of Delaware. I think the diplomatic initiatives that you're engaged in Washington are critically important, because, as you've said, the United States operates on its own basis as far as beneficial ownership registers and other things are concerned. But in terms of the other comment you made about relocating businesses to the Bahamas, I'm specifically interested in relocating family offices here. What work are you able to do with the Department of Immigration to create some sort of streamlined approach where work permits are required, or where the principals of these businesses are coming in searching for economic permanent residence? And obviously, I understand a tax certificate is on its way. And that will be also very important to some of the principals of these businesses.
Yeah. No, I appreciate those questions. Those are very, very helpful. So I'll give you one example of what Christina and I had in mind that pertains to this nearshore operation. And so you look at what's happening under the current U.S. Regime is they have pivoted on their approach to digital assets, for example. And there's a digital asset czar, and they're looking to develop that as a source of business for the United States. Well, we know in the industry that that these digital asset companies and frankly other financial services companies, they have a U.S. operation for U.S. clients, and they have a non-U.S. operation for non-U.S. clients. We believe that, given our expertise, for example, in digital assets, that if we engage at the right levels, we can have a cooperative nature with the United States, where as they develop their regime, we could, one, help them develop their regime, but we could also have a, I don't want to call it an alliance, but an understanding that, you know, we're an ideal, you know, non-U.S. jurisdiction close to you that can help service these clients as well that you're looking to attract, and having that kind of nearshore opportunity. So you're absolutely right. We're definitely looking at that. And that's on our agenda list. And that's just an example of how I think that can work. With respect to the family offices, you know, absolutely. I mean, you know, I try to work with the minister all the time on immigration. We're systematically trying to do some reforms to help what we do on the immigration side. And one of them you raised has to do with economic permanent residencies. And what we've been able to achieve now with the consent of Cabinet and the Prime Minister is we've now created delegated authority for economic PRs. So for those who may not know, every single permanent residency in the country, including economic PRs, have to come to Cabinet, which is really an enormous bottleneck because we don't do immigration matters every week. If we do immigration matters once a month, we're doing well. And so at the Cabinet level, economic PRs trying to get through Cabinet, it was a disaster. And so, you know, I put forth a framework where Cabinet would approve delegated authority to the minister to approve economic permanent residencies with the proper vetting as usual. And that hopefully solves the bottleneck on economics, and we'll be getting economics out a lot quicker with that. One thing I've also proposed on the economic PR side that they're working through with their technology provider to try to make the adjustments to see if we can do it, is can we start the processing of economic permanent residence applications on the signing of the purchase agreement for the piece of real estate. So once you sign the purchase agreement, you can submit your PR information. We can go through it, and we could even give you an approval in principle conditioned on closing, conditioned on paying your VAT, and then conditioned on getting your investment board permit, whereby that 60 days to close on your real property transaction, the immigration work can be going on at the same time. Again, it's delegated authority, so it wouldn't have to come to Cabinet. And the best scenario would be once you paid your VAT and you got your investment board permit, we print the card and you can hand the card over when you close on the property transaction. That's what I'm trying to put in place now. Again, the technology service provider needs to make some adjustments because the system isn't set up to do it on the purchase agreement, it's set up to do it on closing. And so we're working through that issue. But ultimately, that would be where I want to be on the economic PRs, is where we can have a framework in place where when you close, you can get your PR card right away, and then you walk away and it's done. So we're trying with some of these initiatives. You know, government's never quick, so we're working. We're doing our best. We're trying.
One more question?
That
Mike
guy.
to the front.
Good morning.
Morning.
AG, I, I observed with a lot of interest all your radical, what I will call it radical, what all you spoke about. And when you said about the compliance on those 40 criteria as such. But what I'm going to talk here is about the future and something. Bahamas still has to catch up with the rest of the world in terms of the payment portal, fintech. Right in the United States, there is Zelle, and there are other countries, there are similar measures. The fintech has gone very far in a lot of other countries. We do not have that to this extent. And I think that there is a reason for this is because about 50% of the population does not have access to the banking. We rely on web shops. In the family islands, a lot of people do not feel the need for bank account because they can easily do it through the web shops. In this scenario, when the fintech really come in full force in the Bahamas, how do you think this will affect the compliance with those 40 criteria as such? And are we ready for it?
Yeah. No, I think that's a good question. Especially in an archipelagic country like the Bahamas, we've seen brick and mortar banks pull out of islands. That has really caused a problem with payment regimes in the islands. And this is where your example on web shops, because we know web shops aren't pulling out of the islands. And they deal well in cash. I think part and parcel of it is access to technology throughout our jurisdiction. We have some payment portals that exist, right, in the country, within the country. Canoe effectively operates as a payment portal, or can, and there are others. I think part and parcel of the problem is technology. Now, you ask an AML question, and it's a good question, but I look at it and I say, well, how much money laundering is actually occurring in small denomination $B transactions? When you look at a risk-based framework, which we talk about risk-based when we talk about AML, and that's really what we should be operating under. When you look at small payment transactions, below $100 that are always in B dollars, I think your risk to money laundering is rather low. Now, you would have to build the case that it is a low-risk transaction, but if you're using a payment portal such as a Zelle, for example, there would have to be certain onboarding requirements of Zelle so they can know who their clients are. They would fall under, presumably, a licensee of the Securities Commission as a money transfer business. And they would have onboarding restrictions, right, or requirements. So there would have to be some onboarding requirements, but I think on a risk basis, the risk is rather low if you look at small B transactions on a payment portal. So.
Okay, last one.
Well, first of all, thank you, AG Pinder. I think you've been doing an excellent job, in my opinion, representing the Bahamas and really promoting the industry. With that being said, could you provide any comments on the tokenization of real property?
Yeah. So we've seen this in theory, put out by developers or certain promoters in the Bahamas on tokenization of real estate, and what the position is with respect to the tokenization of real estate. I think the proper opinion on that is that it is deemed a security, and because it is a token tied to a physical asset, and therefore the token itself should be regarded as security. I'm looking at Christina for her hand of acknowledgement. And as a security, it should be regulated under the SIA, Securities Industries Act. Now, if a developer would come forward and say they want to tokenize real estate, understanding that it is a security and understanding that they have to go through the regulatory hoops that the SIA and the DARE Act would require, then I think it would be certainly something that the Commission might consider and the government might consider. The problem is the promoters who have been floating this idea out in the marketplace have never approached the Securities Commission, have never approached the government with this idea, and have never acknowledged that they are conducting a regulated activity and we're breaking the law even by promoting that. Christina?
Is that Dylan?
Yeah.
Yeah, so Dylan, you getting me in all kind of trouble with my chairman. Oh, there's Michael. So Michael, you getting me in all kind of trouble with my chairman because this is a very hot topic for him. And he's been after me to develop legislation on the tokenization of real world assets for some time. So what I would say is that we're very likely, there are two aspects to it, So from a regulatory point of view, there are some obstacles in terms of how a regulator will see someone raising funds in a tokenized way to then go out and purchase assets, right? That being said, we do have model that exists in traditional finance for how the raising of assets are done prior to the raising of funds are done prior to the purchase of any assets or prior to any investment. So in as much as we have those models, we are looking at models for tokenization of real world assets that would include real estate. We probably will publish something on that, I would say, before June of this year. So I think you could look out for it. And what the Commission would be essentially saying is that, okay, we already have a framework within the DARE structure for the tokenization of real world assets. So it could be done. What we will be saying in our publication is that these are the models that we're willing to entertain to register in the jurisdiction.
So just to add to that, how do you get around the stamp tax?
The stamp tax issue is above my pay grade.
I don't think you do. It's an interest in real estate. It's an interest in real estate. It's tied to a fixed asset, and that fixed asset is an interest in real estate.
However, if you have an entity that owns the fixed asset and then an underlying entity that provides funding, the entity A that owns the asset never changes. They always own the asset. It's the underlying company that provides financing that can get an equivalent return. And so there'll be no change. So there should not be a stamp tax effect.
No. If you have a lease, which is a possessory interest, which you're saying the token is, right? The token represents a possessory interest in real estate. That's what it represents. If you have a lease, which is a possessory interest in real estate, and you sell that lease, right? You sell it. That's a stampable transaction because it's an interest in real estate.
The essence of the token is that you don't really have the ownership. It's kind of you get the virtual return, but you don't have the ownership. Company A still owns the asset.
I understand. But it's a possessory right. You have some sort of right in that real estate.
You have the right to the returns, not a right to the real estate.
Michael, Dylan is friendlier. on the on the domestic side, I don't think you get around the stamp tax issue, right? And I do take your point with the asset being held, but on the tokenized aspect of it, the buying and selling of that token itself will not attract stamp tax. It's the buying and selling of the real estate that will attract the stamp tax, but not on the token level.
I don't know if I agree with that position.
If I could just make a little input on this, Dylan? Michael. No, if I can just make a small input on this, I think basically you will have the real asset, which will attract stamp duty. The tokens would be a security. And persons who, this is the way I think it will have to work, persons who buy the securities would then, they would be probably buying them to get some profits. But before the profits, in calculating the profits, the stamp duty on the real estate will have to be considered. You see, because they're not going to be buying the old hotel in Freeport. They're going to be buying the token after that's been tokenized. They'll be buying the token, and in selling the tokens, they're going to say, well, this hotel is going to make X amount of dollars a year, and it's going to give you 10% return, and so on. So the hotel will still attract the stamp tax. In calculating the profits, they'll have to take in consideration. That's the way I see it working. There may also have to be some consideration of the Immovable Properties Act to ensure that there's a differentiation between the tokens and the real asset. So the government may have to look at to see whether there's any amendment in that. I don't know, but that's a possibility. But certainly it's an important point and has to be considered.
Okay, well, we're over time, but thank you all for your engagement, and thank you, AG, again, for that very informative discussion. Look forward for the next time.
Thank you. Appreciate it. Thank you, everybody. Thank you.
Good morning. I would like to thank the Securities Commission of the Bahamas' Executive Director, Ms. Christina Rolle, for extending an invitation to me to provide you with an update on the recent developments pertaining to the Common Reporting Standard, otherwise known as CRS. I would like to start by providing you with some background information. The Common Reporting Standard and due diligence procedures were devised and approved by the Organization for Economic Cooperation and Development, the OECD, in July of 2014. The Bahamas committed to the implementation of the organization or the OECD's Common Reporting Standard in relation to the automatic exchange of financial account information in 2015. To further strengthen its commitment with respect to tax transparency and tax cooperation, the Bahamas signed the Convention on Mutual Administrative Assistance in Tax Matters in December of 2017. Also, the Bahamas signed the Multilateral Competent Authority Agreement in December of 2017, together with the Convention on Mutual Administrative Assistance in Tax Matters and the MCAA, formed what is called or termed the International Legal Framework for CRS. In 2016, the Bahamas' domestic legislative framework was implemented with the enactment of the AOI Act in 2016, and the Automatic Exchange of Financial Information Act makes provision for the automatic exchange of a financial account information with a competent authority in a partner country. Further, the Act provides for the implementation of the Common Reporting Standard and due diligence for financial account information in tax matters. The automatic exchange of financial account information regulations followed in 2017, together with the automatic exchange of financial account information guidance notes. And this is what we call the domestic legislative framework. In September of 2018, the Bahamas exchanged information with approximately 35 jurisdictions, and to date, the Bahamas successfully exchanges information with approximately 67 jurisdictions. Since first exchanges, the legislative framework has been amended, with the most recent amendment relating to the CRS anti-avoidance or anti-circumvention rule currently making its way through Parliament. Further, the Bahamas has undergone a number of OECD legislative assessments, and the Bahamas' domestic legal framework is determined to be in place but needs improvement. However, the Bahamas is undergoing the second round of effectiveness review for the OECD's and Global Forum Transparency and Exchange of Information for Tax Purposes Common Reporting Standard during this year, and will be completed by the end of 2026, with the adoption and publication of the peer review report of the Bahamas, hopefully with a new rating. The Bahamas has made significant progress to be granted an on-site visit and therefore has the possibility of improving its current non-compliant rating. In preparation for the on-site visit, the Bahamas will be undergoing a virtual mock on-site visit, which will be conducted by the OECD's Technical Assistance Team on Monday the 5th and Tuesday the 6th of May, 2025. In this vein, the regulators and representatives from the financial services industry will be invited to attend the mock on-site assessment. We have asked the regulators to invite representatives from each of the CRS financial institution categories, which are the depository institutions, custodial institutions, specified insurance companies, investment entities type A, and investment entities type B. The purpose of this exercise is designed to stimulate the peer review process while also providing us with assistance so that we are well prepared to present our CRS administrative compliance strategy and its implementation. The objective is not to fully replicate all sessions of the official on-site visit from the assessment team, which usually spans over a few days. Instead, the mock on-site visit aims at providing a sense of how the on-site would be organized and potential issues that would be discussed with the assessment team, and it will cover key issues relating to the administrative compliance strategy and supervision and enforcement activities. During this session, financial services representatives will be expected to engage in a dialogue on the following points or topics: their experiences, practices, and challenges in implementing the requirements for CRS, reflections on the jurisdiction's approach to implementation, particular challenges faced and any response to these challenges, preventing circumvention, excluded accounts, and engagement with the tax authority with respect to the CRS, including communication channels, outreach, and implementation. In light of the above, we are asking for your continued support, cooperation, and collaboration with the MOC on-site. It is noteworthy to mention that the on-site visit has been scheduled for the 15th, 16th, and 17th of July, 2025. The same representatives from the financial services industry who participated in the MOC virtual on-site will be invited to attend and speak on the same topics. And once again, we ask for your continued support and cooperation with the upcoming assessment. I will move on to the implementation of the amended CRS. The CRS, as you know it, has been amended. In August of 2022, the OECD adopted and published the amendments to the Common Reporting Standard. The amendments to the CRS cover three main topics: the inclusion of digital money products, enhanced reporting requirements on reporting financial institutions, and the incorporation of further clarifications on terms and due diligence obligations. For the CRS AOI standard to properly function, all jurisdictions, including the Bahamas, participating in the AOI standard must do so on the same basis. Otherwise, the AOI standard would be less effective, more costly to implement, and loopholes will be created. Therefore, the Global Forum has agreed that all jurisdictions that have implemented or that will implement the standard must implement the amended CRS. The Global Forum has identified the year 2027 as the common and generally expected exchange year under the amended CRS. Jurisdictions are therefore generally expected to commence exchanges in 2017. This would require the following: amendments to the legal framework to implement the amendments to the CRS, the implementation of the new CRX XML schema to be implemented in time for 2027 exchanges, and the declaration to the addendum to the CRS Multilateral Competent Authority Agreement to be signed and subsequently activated. There might be exceptional circumstances in which a jurisdiction cannot deliver its legislation in time to commence exchanges under the amended CRS. In these cases, jurisdictions can deposit a notification under the addendum to the CRS MCAA requesting that its exchange partners agree to continue exchange information collected under the original CRS for up to 3 years, the so-called transitional period. The transitional period should only be requested for the required additional time needed to implement the updated domestic legislation and not exceed 3 years, leading to the initial exchange year under the amended CRS in 2030, the latest. An update of the current CRS XML schema is necessary in order to include the new fields and values required under the enhanced reporting requirements on reporting financial institutions. Further efforts on our part have been made to obtain the declaration to the addendum CRS MCAA from the OECD. The addendum to the CRS MCAA has been developed and provides an updated legal basis for participating jurisdictions, exchanging CRS information. Once the declaration to the addendum is in hand, same will be reviewed internally by the Office of the Attorney General in preparation for signature and activation. More information regarding the implementation of the amendments to the CRS will be forthcoming. Once again, thank you for your attention.
Ooh, these lights are bright. Good morning, good morning, good morning. We still in morning, afternoon. Okay, so a lot of you, if you're already on the CRS standards, the CARF will kind of be similar, but it's really just specific to crypto assets. So I'm just going to go in and explain about the crypto asset reporting framework. I'm going to give you a little bit of background on what that's about, why it came about. And so the Bahamas commenced exchanges. So this also falls under the AEOI, the Automatic Exchange of Information Framework, which came into effect. The exchanges took place in 2018 for the Bahamas. So in this context, in preserving global tax transparency and with the rapid expansion of digital asset business, the OECD developed a crypto asset reporting framework, which is called CARF, and this provides for automatic exchange of tax-relevant information specific to digital assets. In May of 2023, the OECD, in collaboration with the G20 member jurisdictions, completed some technical work in respect to CARF. Crypto assets, obviously cryptocurrencies, cryptography-based tokens, they're a relatively new method to store wealth and carry out financial transactions, allowing for such activities to be carried out in a decentralized manner outside of the traditional financial sector, that is banks and other financial institutions that we're generally accustomed to. So the use of crypto assets to hold and transfer value has grown rapidly over recent years, catalyzing new ways of doing business and innovation. However, the same decentralized nature and the removal of the need to engage with the more traditional financial sectors has provided obviously new opportunities for taxpayers, including individuals and entities, to hide their income and wealth from the view of tax and other law enforcement authorities. While the traditional financial sector has historically been a focus of regulatory oversight and reporting requirements, including for tax purposes, crypto assets and their intermediaries that facilitate their use have only recently become the focus of such regulation. Similar, we saw that it's under FATF and it's known as VAS, Virtual Asset Service Providers, and for which, as the AG spoke, the Bahamas has a compliant rating. And that is specific to anti-money laundering. But typically, they're not yet subject to any tax reporting requirements. And so basically, the thought is that widespread, consistent, and timely implementation of the CARF will further improve the ability to ensure tax compliance and clamp down on tax evasion, which reduces public revenues and increases the burden on those who actually pay their taxes. For the Bahamas as a jurisdiction where we do host crypto asset active markets, so we intend to transpose the CARF into domestic law and activate exchange agreements in time for exchanges to commence by 2028. So similarly to what's happening with CRS, that plans to come. The hope is that the amendments to the standards as agreed to OECD will come into place, and so all the CRS reporting standards similarly will come on for CARF. So there are some countries who have not signed on to CRS, such as the US, but they are signing on to the CARF. And so we're going to see where that'll go. But I guess they still want to get their money from crypto assets, right? Collect their taxes. So while CARF and CRS have similar framework, the CRS will serve as a blueprint, but it must be reiterated that CARF is a standalone framework. So CARF is considered integral in the AEOI framework, but when we look at what the common reporting standards, there is a difference in the scope of assets and intermediaries concerned, in that the overarching design of the CARF, although it resembles CRS, it is particular to a scope of coverage of just crypto assets. So nevertheless, CARF does share several features with CRS that are relevant for tax administration and service providers to understand possible approaches to implementation. So these similarities would include the annualized reporting, an exchange of information, due diligence procedures will be followed, IT and confidentiality requirements, and so it's a good starting point to review the similarities and the differences. So annualized reporting, like I said, so like CRF, CARF will apply the annualized reporting. RCAPs, as they're known, which will be reporting crypto asset service providers. So that will be the acronym that's used. That when you start hearing that, they're referring to crypto assets that have to report under CARF. Due diligence, and so to the extent possible and appropriate, the CARF due diligence procedures are consistent with CRS to minimize the burdens on RCAPs when they're also subject to CRS obligations. So I know we have a couple of entities in our jurisdictions that are registered with us that may be doing banking business, investment business, and they may also have a digital service provider. So for those entities, it should be a little bit easier for them, seeing as they're already doing CRS. For the ones that are not, obviously, they're going to learn and build in their new systems. So the IT systems are similar. So like CRS, the CARF requires a certain IT systems be put in place by tax authorities. Again, the Bahamas already has most of this in place because we currently exchange for CRS purposes. And then the confidentiality requirements, it's called CDS, confidentiality and data safeguards. So the Bahamas has already passed these assessments under our CRS standards, but obviously they may be updated and looked at once CARF comes into place. Now, some of the differences distinguishing CARF from CRF is when we look at the scope of assets. So the CARF applies basically to a set of assets. So while CRS covers traditional money, your securities, your other financial products, CARF is only concerned with crypto assets. And these assets are distinguishable from financial accounts in that they rely on cryptography and distributed ledger technology, in particular blockchain technology, to be issued, recorded, transferred, and stored. This is done in a decentralized manner without the need to rely, obviously, on traditional financial intermediaries and central administrators. So as opposed to CRF, which covers FIs, the CARF covers a different set of reporting service providers, which will be known as RCAS. And these are required to perform a different set of due diligence and reporting. And they're defined in a functional manner to include both individuals and entities that effectuate exchanges in relevant crypto assets. So while a financial institution can be an RCAS, the definition also includes actors who are not covered currently under the CRS. So there are some RCAS that might not be financial institutions, and of course, they currently would not have experience with tax information collection and reporting, as they're not currently subject to CRS. So some of our DARE licensees who only have that license might have a learning curve, but that's why we're trying to put it out there early, get these sessions out there so you could start asking questions and know what you need to do to prepare yourself. So while CRS requires annual reporting of account balances and information on payment and proceeds, CARF is a transaction-based reporting requirement in exchanges. And so they look at exchanges between relevant crypto assets and fiat currencies, exchanges between one or more forms of relevant crypto assets, the transfer of relevant crypto assets, and these transactions will be reported with respect to a user on an aggregate basis based on the type of relevant crypto asset you have and distinguishing the different type of transactions. The reporting schema is similar to what Adriana referred to with the CRS, so that CRS XML schema, however that goes. So now what do we look at? And so we look at obviously what's needed, political commitment. So in terms of agreeing to a specific date for conducting exchanges, the G20 leaders, obviously, they were hoping for it to start in 2027 for what they called relevant jurisdictions. But of course, they knew that some challenges may come about and this deadline may not be possible for everybody, so they did allow for it to be in 2028, which would mean for the Bahamas, that is what we signed on for 2028. And this would mean that our data will be collected from 2027, so that it can be first reported in 2028. As such, the plan is to have all this information and put into domestic law. We'll have to activate exchange agreements for that first exchange to commence in 2028. The CARF documents, the way they talk about this level playing field, so for the Bahamas, I don't know, but it's supposed to cover all relevant jurisdictions. So for CARF, they have this thing, they call it jurisdictions of relevance. And it's supposed to be an annualized process where they decide, who is relevant, how did you come up? And one of the things is does the crypto asset service provider have a nexus to your country? So in the first instance, when CARF first came about, the way they did this, because this is new, they looked at FATF standards. So they used what FATF used for VASP. And that's how they initially identified jurisdictions that they thought would be a material jurisdiction. So they said, do you host material VAS, in our case, RCAS, but also do you offer a favorable environment for the sector? So we fell into the category of immediately relevant. And so to be immediately relevant, there's a presence of material number of reporting crypto asset service providers in our jurisdiction. And then there was the utilization of the FATF list of jurisdictions that they claim hosted VAS. FATF approached the materiality at the time, and how the Bahamas became listed on that list was that they said that there was 0.25, they looked at this 0.25% of the global trading volume, and that was a de facto threshold, which at the time, under the 2022 data, was about $231 million US. An important information for sourcing this that they used at the time when identifying was they said they conducted a comprehensive review, basically, of publicly reported information from the crypto market, and they included the top 100 VAS by trading volume, which they said basically those top 100 accounted for 99% of the global trading volumes reported by all the VAS. So then they focused on those ones, that's what FATF did, and then they used this information, which was open source information, example, self-reporting from CoinGecko. They also cross-checked it to information by blockchain analytics, so Chainalysis, TRM Labs, they do feed information to FATF, they give them the information, and that is where they got it from. So second, FATF used the available information, and they looked at each VAS, where it was located, where it's licensed and registered, where it's incorporated, physical location of your headquarters, and then they had a little quirky thing in there where they looked at the size and the length. And what they did was they said, listen, the top 15 VAS by global market share, which was responsible for over 90%, it was attributed to each and every jurisdiction in which they were identified as even having any type of entity, having any licensing, having any incorporation. So the total trading volume for the largest set of VAS was given to a bunch of multiple jurisdictions, right? And FATF took that approach because that's what they felt would be the best way. Now, CARF took that as a base, but going forward, their hope is just to rely on that. But they said, you know, one of the things is you can't just do that straight across the board. I don't know, in terms of fairness and equity. So one of the things they are going to do, though, CARS is going to say to be a RCAPS in this jurisdiction under count, they will look at, is it resident specifically for tax purposes? Is the entity incorporated or organized under the laws and jurisdiction of that country? Is there a legal personality in your jurisdiction? Do you have an obligation to file tax returns or tax information to your local jurisdiction authority? Is the entity managed in your jurisdiction? Is it an entity or an individual, and do you have a regular place of business? So there has to be a sure nexus under CARF to your country. So that is a slight difference to FATF, right? So we were considered, again, immediately relevant. And so one of the other things was that they looked at, does the jurisdiction offer an attractive location for RCAS? And for them, what they call an attractive jurisdiction was, do you have a legal and regulatory environment that is explicitly designed to be favorable? Do you have a welcoming environment? Do you have a dedicated regulatory regime, which may include licensing and registration requirements? Does the jurisdiction promote itself? Do you say, hey, we have favorable business for crypto asset sector. Come and bring your business here. Do we have policies in place? Do you promote yourself in the private sector as having favorable legal or business environment for the crypto asset sector? And so that was a second reason why we were considered immediately covered. Also, is there a significant crypto asset user base? And so while the presence of that may not mean that there's a nexus to your country, that is something they looked at as well. And so when we think about readiness, obviously there's the commitment to implementing the CARF, which we've stated there is a political will to do so. So the Bahamas has signed on to the CARF Multilateral Convention on Mutual Administrative Assistance in Tax Matters, MCAA, let's go with that. So what we need to do though now, and so what they're working on, what the AG's office and the Ministry of Finance are working on, is getting the actual domestic legal framework in place. So we have that in place now for CRS, and obviously there are some amendments taking place for CRS. They're gonna do the same thing for CARF. We want to have a set of due diligence, reporting deadlines. You know, you have to put out official guidance in respect to your domestic implementation. We want to have industry briefings. So we'll be doing more of these specific to CARF as that comes along. And then, of course, we need the administrative and IT frameworks. So again, for those, because we have the framework online for CRS, and both of them are under the automatic exchange of information under the AEOI, the IT and administrative portion should be fairly easy for us to just adjust, because that was how it was made for both of them to work together. And then the confidentiality and data safeguards assessment. So they are in place currently, as I stated, and we've passed those assessments under the CRS. So just be prepared and get ready. Like I say, we're going to start looking at the 2027 data with the first reporting of 2028. So that is where we are. Let me show.
Good afternoon, ladies and gentlemen. And thank you to Adriana and Leslie for your insightful presentations. These frameworks are crucial in ensuring global tax transparency and the exchange of financial account information, now extending to crypto assets with CARF. I'm mindful of our time, so I want to get straight into asking questions. Adriana, you mentioned that our domestic legislative framework is already in place and has been since 2017. So to that end, can you provide us an overview of where the Bahamas stands in terms of CRS implementations and what has been some milestones thus far?
Thank you, Lamesha. The Bahamas made a commitment to implement the CRS in 2015, and by signing the convention and the MCAA, the international framework was established. Shortly after that, in 2016, the domestic framework was implemented with the enactment of the AOI Act and regulations and guidance notes. Also, the CRS AOI portal was installed, and all the aforementioned steps paved the way for the Bahamas to commence first exchanges in 2018. As the Bahamas now exchanges with approximately 67 jurisdictions, we recognize and consider this as a significant achievement for the Bahamas. Further, the development of the CRS compliance strategy and the upgrading of the CRS AOI reporting portal and the upcoming assessment is evident that the Bahamas continues to make significant progress with the implementation of the CRS. Thank you.
Thank you. Both you and our chairman referenced the upcoming assessment in this July. So what specific areas do you anticipate will be closely scrutinized, and what do you think are some of the key compliance factors for the OECD to be looking at?
Lamesha, there are a number of areas that will be closely scrutinized. The compliance actions conducted by the regulators or designated supervisory authorities, such as desk-based reviews, on-site audits, together with enforcement and sanctions, will be closely scrutinized. And as you are aware, statistics also aid in providing a narrative on your jurisdiction's activities. With respect to financial institutions, apart from your experiences and challenges in implementing the standard, they would want to know that the FIs have policies and procedures in place, that they are carrying out due diligence procedures in accordance with the standard, and applying the definitions correctly. Thank you.
Great. So one last question, Adriana, before we move on to CARF. You mentioned the financial institutions and the role they play. How would you say the financial institutions and other stakeholders in the Bahamas have adapted to CRS requirements? And are there any compliance gaps or best practices that you can highlight?
Lamesha, financial institutions and other stakeholders such as BFSB, AIBT, the Insurance Association, have embraced CRS, and they are always willing to cooperate and collaborate with the competent authority. When we are implementing OECD initiatives, industry and other stakeholders are always invited to the table. I recall when we were drafting the CRS AOI legislation, representatives from the financial services industry formed a part of the CRS AOI working group. We always have fruitful and productive engagements with industry, and for this, we are very thankful. Comments from our peers relate to the low numbers of TINs and date of births that are reported, incomplete filing, and the accuracy and quality of information being reported. And this is why we engage industry to bring issues from other jurisdictions to their attention so that they can be made aware of them and they can address them. Bear in mind, LaMacia, FIs play a vital role in the success of our initiatives, as the information they report is exchanged and peers or relevant jurisdictions are asked by assessors to provide their input or comments on the information exchange. So the success of the outcomes of our assessments is dependent upon industry as well.
Agreed. Thank you, Adriana. Leslie, piggybacking on the topic of compliance, we know crypto assets are inherently decentralized and compliance may be more complex than with a traditional financial institution. What do you think are some of the key challenges the Bahamas may face in implementing CARF?
So I think one of the, okay. I think one of the things is obviously it's a learning curve initially. Hopefully it would fall in place easily because a lot of our licensees and registrants already are in line with CRS initiatives. The other thing is one of the reasons we're trying to do these industry briefings in advance is so that questions are answered, but due diligence is always, that's one of the big things, and so we're going to be wrapping up our examinations process. We want to go out in the field more to ensure that these type of things, KYC documentation, due diligence, that it's being kept up to ensure that by the time as this comes into place, we're more in line.
Okay. One last question for you, Leslie, before we move to the audience. From a regulatory perspective, how do you think the Bahamas' approach to CARF aligns with global trends?
Well, I mean, it aligns because this is under the Global Forum. The G20 countries are a part of it. The Bahamas is a part of the OECD. We have already taken on CRS, and this falls under the AEOI current framework. So this is standard. It's going to come whether we like it or not, and we're going to have to sign on. So.
Yeah. Excellent. Thank you, Leslie. Do we have any questions from the audience? We have one in the front.
Sorry, I had so many questions I had to stop writing. so there are a lot of questions, but I do appreciate the fact that you're starting early with the education and awareness of CARF. Now, I didn't hear anything about, I know you're aligning it with CRS reporting. And that's very different, I think, when we start to talk about crypto assets and then going a little further into blockchain. And then we have our reporting standards with the SEB under the DARE. The expectation of the reporting under CARF, is it minimum, or do you expect that this will be an onerous process which will not only add to resources or resource requirements for organizations, but also, if you could also give me a little idea on what you think the tax implications are as it relates to AEOI?
So, I mean, CARF and CRS are both under AEOI. They're both part of the AEOI framework. In terms of it being onerous, I mean, it might feel that way for persons who, if you have not done CRS and maybe don't have your IT systems in place or don't have anything in place currently, it might feel that way to you. And it's a lead up time, but once the systems are in place, there will be a portal similar, it'll be the similar portal to CRS. So I think it'll be a learning curve, obviously. Any reporting probably for industry always feels like too much reporting,
but it is something that it does have to happen.
Okay, and also, well, you said it was a transaction-based reporting. So that means every transaction
Yeah,
will have
so
to.
it'll be split where it'll kind of look at what your different transactions are, what is that in relation to, and that's how CARF will have to be reported.
So the portal, the existing portal used for CRS,
Yes,
we'll be using that same one for crypto asset reporting?
that's my understanding. I mean, now there would probably have to be some type of tweaking in place, but as far as I know, the way they both fall under AEOI, and the plan is that it all feeds into the same thing. Yeah.
If I could jump in with the question Reese have. I think, Reese, the biggest issue for digital asset businesses will be their need for technology to monitor transactions. So currently, for example, the commission subscribes to Chainalysis, right? I would imagine that they will need some technology service provider to monitor transactions and to report on transactions and be able to report on those transactions. So I would imagine those systems are probably going to be built into the software of most technology providers over the coming 2 to 3 years. But in terms of it being onerous, I would probably say it will probably be a cost associated with the level of reporting that's going to be required.
That was, yeah, that was a part of what I needed to understand, that the cost factor, right? And how we would be able to, you know, how this would add to our cost in terms of budgeting. And also this final question, the reporting crypto asset provider. I just need a little bit more information on that person, or is it a company, or like how are you looking at who will be a reporting crypto asset provider?
So persons under the DARE Act now, if you would be, because it's more than just doing an exchange. So if more than likely, if you're in that business, that's, you know, how your licensing come now. You'd be considered a crypto asset service provider, and based on and I'm assuming, even when we talk about cost being onerous, I'm assuming to be able to run a crypto asset business now, I'm hoping that you have some of these technology in place already in order to facilitate your transaction. So there may be an additional cost, but it's hard to imagine somebody under the DARE Act with no type of technology in place currently. So yes, it'll probably be something to add to it, but that's a part of the cost of doing business, unfortunately.
You're in the Ministry of Finance?
I am not. I work for the Securities Commission of the Bahamas. Adriana is with the Ministry of Finance. Currently, the Ministry of Finance is the competent authority for CRS, and there's delegated authority to the. When we come to that, we will let you know. But once again, it's a collaborative effort. Thank you.
Thank you. We have time.
No, sorry. I just I'll just repeat what I said. I was just saying that you're under the SCB, and Adrian under the Ministry of Finance. I just wanted to know where the budget stream was, first of all, in terms of which ministry that's going to take on this reporting requirement. But most importantly, that it seems to be two separate organizations.
No,
No.
But one portal.
It isn't separate at all. So, for the purpose of CRS, the Ministry of Finance is the competent authority, right? Recently, and I'll speak to this in a few minutes, the Ministry of Finance have delegated functions to various regulators with respect to CRS regulatory supervision. Where the commission comes in is that as the subject matter expert on digital assets, we have been brought in to contribute to the OECD's CARF framework. What Leslie has explained is that where that framework currently sits is that it's still being fleshed out. So there are only high-level principles where that framework is going directionally, but you probably won't have a very clear view of what that framework is going to shape up to be until maybe 2026, late 2026, or 2027 even. And so the framework hasn't yet been rolled out by the OECD. We don't know yet whether that framework will be able to piggyback off the current CRS platform, because we simply just don't know enough about the framework that's going to end up being the framework that has to be reported on. What we can tell you is that based on the way the framework exists for existing CRS reporting, when it comes to, and that reporting is at an account level, what we can tell you is the direction of that framework looks like it's headed in a transaction level, and that will probably require a different level of monitoring for digital asset businesses.
Just similar to that, CRS similarly sits with the Ministry of Finance, but again, each of the competent regs. So for financial institution, for banks, central bank would look at those persons. For securities, we would look at the persons for CRS. So that's the way it is. From a legislative standpoint, it might be sitting at one level for the competent authority, but then you have to look at the regulator that deals with them, those registrants, and we would liaise with you at that level, if that helps.
Again, Adriana and Leslie, thank you for your presentations and for answering our questions. Ladies and gentlemen, thank you for your engagement.
Thank you, ladies. Our next presentation is going to be providing insights on the National Risk Assessment, and it will be given by Ms. Tammy Butler, who is Deputy Manager in the Policy and Research Unit of the Commission. She'll be followed by Ms. Christina Roll, who will speak on the Commission's 2025 priorities and preparedness initiatives, and she may address some additional questions.
Good afternoon. Thank you, Monique. Okay, so for the sake of brevity, I'll provide a high-level overview of the Commission's risk rating methodology, the results of the assessment, and the Commission's action plan resulting from the assessment. So the Commission is responsible for overseeing the securities and capital markets, the investment fund sector, the digital asset businesses, and the financial and corporate service providers. As such, for this risk assessment, the Commission was tasked with preparing a risk assessment of 3 areas under our purview: the securities sector, the investment fund sector, and the financial and corporate service providers sector. The digital asset sector was addressed in a separate risk assessment. At the time of the assessment, we reviewed the risk profiles of 167 firms in the securities sector, which includes our registered firms, marketplaces, and clearing facilities. 43 firms in the investment fund sector, which includes restricted fund administrators and unrestricted fund administrators, and 246 financial and corporate service providers. The risk assessments conducted by the Commission carefully considered the elements and methods of money laundering, its risks, and threats inherent to the Bahamas. In developing the risk assessment methodology, the Commission was guided by international best practices and global money laundering topologies prepared by the Financial Action Task Force and the World Bank. In particular, we used the World Bank's National Money Laundering Risk Assessment Toolkit to identify areas that required improvement. There are several modules covered in this toolkit, of which the Commission used Module 4, that provided guidance to assess the securities and investment fund sector, Module 6, that provided guidance for other financial sectors, including the financial service providers, and Module 7, that provided guidance for non-financial sectors, which encompasses the corporate service providers. In preparation for completion of this toolkit, we conducted a comprehensive data collection exercise to gather information on AML controls, client base, products and services, geographic exposure, and other money laundering risk areas of which the Bahamas is susceptible. To accomplish this, we reviewed the existing data in our database and distributed a survey to our registrants and licensees. The surveys were based on FATF's and the World Bank's standards and requirements, as well as requirements set out in our relevant legislation. Once we reviewed the collected data, we used the World Bank's toolkit to generate the results. Each sector was assessed against general factors and inherent risk vulnerabilities. Upon receiving the results, we were able to interpret them for the report. The securities sector's inherent money laundering vulnerabilities have been assessed as medium-high, while the overall money laundering risk was assessed as medium. The general considerations for the sector are associated with the size of the firms, the complexity of the portfolios managed, the use of legal persons and arrangements, and the client base profile. The investment fund sector's inherent money laundering vulnerabilities have been assessed as high, while the overall money laundering risk was assessed as medium-high. As we used the same module to assess both the securities and the investment fund sectors, the general considerations were nearly identical. The inherent money laundering risk for the corporate service provider sectors has been assessed as high, with an overall rating of medium-high. This stems mostly from the potential for corporate structures to be used for illicit international activity. The inherent money laundering risk for the financial service providers was assessed as medium-high, with an overall risk of medium. In terms of the AML controls that we considered for the overall risk rating, the Commission looked at 1, the extensiveness of the Commission's legal framework, 2, our supervisory and enforcement efforts, 3, collaboration efforts with international and national authorities, and 4, the entry controls of the firms in the markets and their clients. With the results ranging from medium to medium-high, the Commission notes that the actions required have to be sustainable operational adjustments, as the inherent risks are generally rated high, and there would be no one-off remedy to address them. Our current procedures related to examinations and monitoring are robust and are at the core of our AML risk management framework, but the Commission accepts that there are certain areas that we can develop to assist us with further mitigating the money laundering risks posed to our sectors. Firstly, the Commission must continue to develop systems which increase our data management abilities. This will mean sourcing and applying both technical and operational frameworks to ensure the collection, allocation, and analysis of data available by the Commission. This data development project will be directly connected to the enhancement of the Commission's statistical reporting framework, which will ensure the Commission's effective and efficient use of the data that it collects. While the Commission currently collects and stores data, we believe that the further structuring and development of a statistical reporting framework will assist us in further understanding the market data to make more effective supervisory and enforcement decisions. We will continue our efforts to automate the Commission's regulatory systems and processes. While the various sectors under the Commission's purview have adequate legislative provisions, we note that there is limited automation of systems at the regulatory level. To this end, the Commission established its Project Butterfly, which is the Commission's data and software transformation project, which is aimed at updating software and other technology to automate the regulatory monitoring and tracking to ensure that compliance and a consistent and timely response to breaches. We began this initiative in 2022, and in 2024 launched the reintroduction of our Cori software for applications and mandated filings. Finally, a key part of the Commission's approach is to ensure that there is effective sanctioning for all breaches related to money laundering, terrorist financing, and proliferation financing. The Commission will enhance its enforcement and intervention measures, including the application of administrative penalties on a consistent basis to address non-compliance with AML-related breaches. Oh, thank you, sorry. Go. Ms. Rowe?
You know, when Shirin asked me to provide lunch, I assured her that I would have you out of here in time for you to buy your own lunch. And here we are. Thank you, everyone. A special thank you to all of you who represent our registrants and licensees across the scope of the Commission's regulatory constituents for making the time to join us today. This is a very important briefing, and we are pleased to see the strong numbers and keen interest in hearing from this morning's presenters as we prepare for these upcoming international assessments, which have consequential implications for the future of the Bahamas as an international financial center. We at the Securities Commission thought it was very important to bring the industry together to discuss what our priorities will be over the coming weeks and months, and to provide you with an initial opportunity for discussion and context setting on what we think some of the focus areas will be for international assessments, which in turn impact the focus of our on-site and desk-based examinations, reviews, and supervisory initiatives. Importantly, we want to use this opportunity to sensitize the industry to your role in the process, where you need to be focused, and the implications for you as we seek to ensure the jurisdiction is successful in these peer reviews. I thank Attorney General and Minister of Legal Affairs, Ryan Pinder, for making time to share with us some of the latest developments regarding the United Nations initiatives surrounding tax policy making and concern around inclusiveness in the decision making. I also wish to thank Adrienne Knowles-Ramming and Leslie Pearson for a very informative review of the Common Reporting Standards and amendments to the Common Reporting Standards. And of course, thanks to Tammy, Deputy Manager in the Office of the Executive Director, who provided an excellent overview of the National Risk Assessment and its role and significance in the jurisdiction's anti-money laundering and countering terrorism and proliferation financing measures. The background to all of this was important because for the purpose of CRS and also for the purpose of FATF and CFATF and these assessments, whether it's the INSA report that's produced and published by the United States or the National Risk Assessment. These set the stage for what the narrative of the Bahamas will look like. I'd like to also say thanks to our moderator, Sam Campbell, and also Lamisha Cox, who is the Commission's legal counsel, for the excellent panel moderation. As we wind down now towards the end of today's briefing, my goal for this presentation is really to provide you with an introduction to the Commission's initiative over the coming months in order to prepare the case that we present on behalf of the jurisdiction in order to show that the Bahamas has both an effective and sustainable regulatory and enforcement framework for compliance with international standards and best practices. I will be as short as possible in order to allow time for your questions, because I believe this is where the most value can be achieved. So let's just start with a discussion on the Common Reporting Standards. The Bahamas underwent its initial peer review by the Global Forum on Tax Transparency, covering the period 2020 to 2021. After a formal meeting in Paris, the results of this review were finalized and reported on in 2022. What you see on the screen are the results for each review category and the overall ratings for the legal framework and effectiveness. Under the peer review process, there are two sets of core requirements for the legal framework being in place and effectiveness in practice for AEOI measures, with the lowest scoring for each element determining the overall rating. So you see it's split between a domestic framework and an international framework. In the most current update from the OECD revised in December 2022, the overall determination was that the Bahamas' legal framework was in place but needs improvement. However, on the initial review of effectiveness in practice, the Bahamas' domestic information collection and reporting were deemed non-compliant, and as a result, the overall effectiveness rating received a score of non-compliant. So these are the ratings the jurisdictions, so these ratings are the jurisdiction's starting place heading into the next round of mutual evaluations, which is scheduled for July. I'm trying to move forward. Oh. With respect to the CRS timeline, Adriana provided a fairly comprehensive overview of AEOI and CRS compliance going back to some of our initial automatic information sharing arrangements. So I won't elaborate on them further, but focus instead on activities during the last quarter of 2024, what we are doing now and what is coming imminently. On the 1st of October 2024, acting under our authority pursuant to Section 14.2C and G and 14.3K of the Securities Industry Act 2024, the Commission issued a directive to securities industry firms and Investment Fund Act administrators to conduct a self-risk assessment on the sufficiency and robustness of Common Reporting Standards internal control, and to develop a comprehensive risk management system in order to take appropriate measures to manage and mitigate those risks. 7 financial and corporate service providers deemed to have CRS exposure were also sent this communication. This was essentially a starting point for the Commission to have baseline data for insight into the state of readiness of the industry for this upcoming CRS review. It was also intended to alert the industry that they should have assessed their responsibilities stemming from the CRS legislation and guidance notes issued, and have appropriate controls and risk management systems that show they understand their responsibilities and have processes and procedures set up to comply with the requirements of the law and any attendant guidelines. A very important development has been the automatic exchange of financial account information competent authority delegation of functions order 2024. The order aims to give financial regulators, such as the Securities Commission and the central bank, greater responsibility and authority to oversee and enforce compliance by their respective licensees with AEOI requirements. I will discuss changes to the order and other items on the timeline in greater detail on the next slide. Under the order, the functions necessary for the regulatory administration of CRS are delegated from the competent authority to financial services regulators with respect to their respective licensees and registrants. Since the publication of the delegation order, financial regulators have been working diligently with the competent authority, which is the Ministry of Finance, to amend the order so that we have clear legislative authority and the requisite powers to properly discharge the responsibilities being delegated under the order. These proposed amendments to the order will focus mainly on ensuring that regulators have adequate powers of enforcement. We are also working to finalize and sign a multilateral memorandum of understanding between the competent authority and the regulators to ensure that there is clarity and procedures exist to govern how we cooperate together. The amendments are critical, and we look to them being in place and an amendment order being published within the coming weeks, certainly by the end of April. Regarding the actual commencement of the peer review process, Ms. Knowles-Ramming provided details in her presentation with the first assessment day scheduled for Tuesday, 15 July, about 110 days from today. Under the lead of the Central Bank of the Bahamas, we are also working with KPMG, who has experience globally with other jurisdictions undergoing this peer review process, to develop a framework that will help all the regulators ensure they have robust processes and related policies and guidelines in place to meet the AEOI CRS requirements. KPMG will also assist regulators in developing surveys, desk-based reviews, and other tools and mechanisms to enable us to demonstrate effectiveness. All of this has implications for our registrants and licensees. You should expect a CRS desk-based review assessment. Under no circumstances will the Commission be able to tolerate less than a 100% response rate to these assessments. Additionally, if you are subject to an on-site examination within this year, you can expect a deeper dive, and I can tell you we have about 70 scheduled for this year. You can expect a deeper dive into CRS compliance, particularly as it relates to reportable entities and your verification processes. We expect that as the frameworks being developed with KPMG are fleshed out, we will provide training and supporting information to all our registrants and licensees as appropriate. I encourage you all to take advantage of the opportunities to engage with the Commission and to seek out our help. At the end of the day, our aim is to encourage compliance, and we prefer to do this in a cooperative way rather than through enforcement. I swear, we really do. Our Chairman, Justice Adderley, in his opening remarks, mentioned the recent success the Bahamas attained securing compliant or largely compliant ratings in the CFATF mutual evaluation of the jurisdiction's compliance with FATF's 40 recommendations concerning combating money laundering and the financing of terrorism and proliferation, or what we refer to as AML, CFT, CPF. The Bahamas' mutual evaluation report for the fourth round of assessments was adopted in May 2017 during the CFATF plenary held in Trinidad and Tobago. At that meeting, the Bahamas was deemed to have structural AML deficiencies and was recommended to enter into an enhanced monitoring process. Since 2017, there have been a number of follow-up reports, finally leading to the December 2022 re-rating and are 40 out of 40 compliant or largely compliant status. While the results are indeed to be celebrated, I can tell you it has been a long and painful road to get here. We are now in the throes of preparing for the 5th round of AML-CFT mutual evaluations with the technical compliance questionnaire and supporting documentation due in March next year, and the on-site visit scheduled for September 2026. I want to pause here just to highlight that the Commission has encouraged our examinations, supervisory, and enforcement staff to become assessors in the CFATF mutual evaluation process. This truly deepens the Commission's capacity to prepare itself and our constituents for these evaluations, including developing effective strategies and tactics to address requirements and respond to requests, challenge conclusions, and overall to enhance our capacity to demonstrate understanding of the principles underlying the recommendations and effective compliance with them. By extension, the entire jurisdiction benefits from this level of training and exposure. I want to commend the Commission's Head of Internal Audit, Leslie Pearson, for her participation as the lead financial assessor in several mutual evaluations of other jurisdictions. Leslie is also the only assessor from the Bahamas to participate in the International Cooperation Review Group, which oversees the process for enhanced monitoring of high-risk jurisdictions. I also commend CFATF assessors Mr. Ronaldo Harding, Manager for Examinations at the Commission, and Mr. Austin Smith, Deputy Manager for Examinations, who have both participated as lead financial assessors in mutual evaluation of other jurisdictions. And if you can't figure out what the significance of a lead financial assessor is, you should imagine that for any CFATF mutual evaluation, the financial assessment is the vast majority of the assessment that is taking place. We anticipate for the 2026 mutual evaluation that CFATF assessors will focus on certain high-risk activities as well as procedures in place to mitigate the AML, CFT, CPF risks of such activities. Focus areas are likely to include digital assets, international business companies, procedures around politically exposed persons, and the implementation of the travel rule. On the domestic side, my guess, and it's just my guess, is that much focus will be given to the gambling sector, particularly web shops, as well as to human trafficking. Assessors are also likely to hone in on the issuance and enforcement of penalties and sanctions, criminal actions brought and successfully prosecuted within the jurisdiction, as well as the forfeiture and seizure of assets. The Attorney General in his presentation spoke to the International Narcotics Control Strategy Report, or the INSA. The report makes statements such as, investigators and prosecutors routinely use poker, but do not adequately use poker to seize and forfeit assets. And despite extensive training and improved investigative and prosecutorial abilities, Bahamian law enforcement and prosecutors are hesitant to investigate and prosecute complex financial crimes and seize real property and assets derived from illicit activities. When authorities pursue cases, an accepted culture of adjournments delay the adjudications for years. Ladies and gentlemen, licensees, I cannot stress to you enough that these types of statements are typical and represent a deeply entrenched view of the Bahamas' attitude and approach to financial crime. While I can and I would agree that there is much about this narrative which requires contextualization in order to paint an accurate picture, the truth is this is the uphill climb of the narrative we are facing. As a jurisdiction, we must be deliberate and focused in reframing and steering this narrative to a more fulsome representation of the conduct of financial services in the Bahamas. we must first contextualize both the domestic and international business operating from within the jurisdiction, demonstrate effective and deterrent enforcement, as well as international cooperation, and foster a narrative of a jurisdiction that is committed to the highest standards and best practices when it comes to combating money laundering and terrorist financing. This is the only way that we can ensure the survival of our industry and our livelihoods. Finally, compliance with international obligations, Economic and Ancillary Measures Act, particularly regarding the obligations related to United Nations Security Council resolutions, is an element of the AML CFT CPF evaluation process. I'm pleased to say that the group of financial services regulators are working to streamline the reporting requirements in this regard. Details will be coming out soon, but I can summarize by saying that nil reporting requirements as well as quarterly reporting will be removed. That's all the compliance officers. So financial regulators will also align on the use of the same reporting form. We have not yet gotten to the point of a single reporting platform, but this will at least bring us one step closer. While compliance will be much more manageable for almost everyone in this room, there is also the added benefit of greatly reducing and being able to restate non-compliant statistics, as well as painting a more accurate picture of the terrorist financing risk within the jurisdiction. In other words, by requiring that licensees report on 0 hits, we create a forced non-compliance every time a licensee does not file a nil report. This then has the knock-on effect of giving an impression that there may be a high risk of terrorist financing in the jurisdiction. By removing the requirement of nil reporting, regulators are ensuring that risks are appropriately monitored and reflected. However, your requirements to ensure that your client databases are updated and cross-checked against these UN resolutions are not diminished. We are only streamlining the reporting process. There are a number of activities that will occur over the next 12 months as we ready ourselves to submit the technical compliance questionnaire and undergo the subsequent mutual evaluation. Critically, the Commission will be focused on gathering and compiling compelling statistics that demonstrate the effectiveness of the AML CFT CPF regime. Data must demonstrate that we have a strong grasp of the activities taking place in the jurisdiction, particularly high-risk activities. Data must also demonstrate that you understand and comply with AML CFT CPF requirements. In order to secure the data we need, we will use surveys, risk assessments, thematic reviews, and examinations focused on AML compliance. With all of these activities, the Commission is again expecting 100% responses and compliance from all our licensees and registrants. Related to this, licensees should understand that demonstrating effectiveness will mean that we must be able to show penalties and/or sanctions are issued for non-compliance. This encompasses a focus on enhanced tracking of penalties and reporting. For example, penalties will be levied for AML breaches coming out of examinations conducted in 2024 and 2025. And we are hoping that we will be able to show a year-on-year decrease to support an argument that we are trending towards improved compliance and thus can sustain our effectiveness in AML regulation and compliance. Ladies and gentlemen, that brings me to the end of my presentation. Thank you all for listening so intently. I now open to the floor for any questions you may have.
Thank you very much, Executive Director, for your presentation. And now I'm actually much clearer on I'm clear on the authority in terms of the CRS. And I think what you mentioned was that there would be a memorandum of understanding between the competent authority. And I'll say that that is a big step in terms of our assessment, because the competent authority was seen as not so competent. And I'll say that here, but not around the table, of course. But now that the competent authority has given that, through a memorandum of understanding, this is what it seems to be, that the regulators would now take on that authority to ensure that the CRS reporting is in place, along with, of course, the crypto assets reporting. So now I see the line. That's what I was trying to get at earlier. But what I wanted to say here, and maybe you can give a comment on it, was I remember doing some of the assessments, NRA some years ago, and even one of the other assessments about 2 or 3 years ago. And we were at a round table having discussions with, of course, the persons that were here to do the assessment. And what I found was that industry's comments at that table was contradicting sometimes the regulators and even sometimes government policies. And I thought that in itself was detrimental to our progress. And what I'd like you to just make a comment on is, and you mentioned it earlier about the narrative that we sell as an industry ourselves. The narrative is more about conflict or contradictions instead of progress, unity, or collaboration. And I think at some point, especially with these sorts of assessments coming up, and it seems to be more and more pressure, we have to align ourselves. And there has to be innovation, trust, but collaboration is also key. And I just wanted you to touch on that for a second.
Thank you for that, Reese. And there's probably a whole lot I could say on this topic. But what I would say is that what the industry should appreciate about the assessments that are coming up is that it's not the regulators that are being assessed. Really, it's the industry that's being assessed. What the regulators are doing is that we're making the case for the industry. We're in front of the case, and we're making it on behalf of the jurisdiction. We're putting our best foot forward to say, look, the jurisdiction is okay because of this, this, and this. So the assessors will interface with us primarily, but they will also interface with industry representatives. Now, the good news is we get to choose the representatives. We always get to choose the representatives. We have some guidelines on who they would like to see. Like, for example, they may say that they want to see someone who has a medium-sized firm in the securities sector, a large firm in the digital asset space, and a small firm in the FCS space. So we get to choose from among the criteria who the assessors will see. And when we're choosing, we try to look through, who do we think have the best rates of compliance, and we try to put them forward. But the truth is, and Reese raised a very good point, the truth is, we don't get to be in the room with the industry and the assessors. And I can tell you from some of the narratives that end up on the mutual evaluations, we know that the industry let us down. We know that they did. We know that they probably didn't demonstrate that they have an understanding of their AML risk. And so it's there's only so much coaching we can do, but we must ensure that we understand our risks. And if you're not sure, just ask. Ask us to give your staff some training on it. Ask us to provide you with more information. That's what we're here to do. And also remember that, these assessments and an opportunity to sit in a room with an assessor and gripe about the regulator. You know, that's going nowhere. It really isn't. The only thing you're going to accomplish is to demonstrate that there may be a lack of cohesion in the industry in terms of your ability or willingness to comply with your regulatory obligation. And so I think we have to approach these assessments with maturity and with a level of professionalism that will ensure that our jurisdiction at the end of the day puts its best foot forward. Any other questions? Okay. Well, if there's no other question, I think I could release you to go and fend for yourself out in the jungle. I'm hungry too, if it's any consolation. Thank you very much.